Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Welcome back for another episode of Legal Tea. Today's topic is a current trend, so something going on in the current time that is pertinent to my little estate and elder law world. Now, this week's episode involves a name that everyone knows, Taylor Swift. So Taylor Swift has a new song, and it's called Anti-Hero. If you have any social media accounts like TikTok or Instagram, I'm sure you have heard of this song, or even on the radio, you may have listened to it. It's quite the popular song right now, to say the least. Now, in this Anti-Hero song, she has a few lines in it that read as follows. I have this dream, my daughter-in-law kills me for the money. She thinks I left them in the will. The family gathers round and reads it, and then someone screams out, she's laughing up at us from hell. I had not really paid too much attention to the words of this song until one day I was in the car and traveling to one of my satellite offices. And I was sort of mindlessly listening, and that part of the song happened, and I was like, did I just hear what I think I heard? So of course, I get to my destination and I eagerly start Googling the lyrics, and son of a gun, I did hear it right. And anytime I hear little things like this, I always think, oh, can I talk about this on my podcast? And it hit me, light bulb. I could totally talk about the Slayer rule in light of what the lyrics say. So what is the Slayer rule, Jenny? Well, in much less legalese, the Slayer rule basically says that you cannot murder someone and benefit from them, like in terms of an inheritance. You can't gain something by murdering them. That's bad, bad, bad. And that makes sense too, right? We don't want people hitting tough times and thinking, well, heck, Granny's 95 and it's just time for her to go because I need some of her money. That's awful, right? Now, the infamous Slayer rule is, I believe, present in every state, but every state handles and processes the rule in conjunction with estate law by their respective state laws. Though if I had to guess, I bet every state is fairly similar because the main principle that we're trying to keep in mind is what I just said. We don't want people to think that it's socially acceptable to murder, then inherit from who they just murdered. So just FYI, some states call this rule the Slayer's rule. Some call it the Slayer Statute. It's kind of a tomato sort of thing. For sake of this podcast being based in the state of Indiana, I primarily focused things on how this state deals with this rule. The Slayer Statute, Slayer Rule, here in Indiana can be found under our Indiana Code's probate code. And specifically, it deals with this sort of thing kind of uniquely. And actually, in 1983, a case went to the Court of Appeals here in Indiana to test how our Indiana Slayer Rule works. That case was Turner versus Estate of Turner, and so we're clear and get a firm understanding of things. Let's talk a little bit about the facts and what happened in this case so that we can better grasp the Slayer rule. So in this case, a son, his name is Alan, shot and killed his parents in Johnson County, Indiana. The son, the following day, was charged with their murders. Through all the hustle and bustle, Alan was actually found not responsible for the deaths by reason of insanity. Now, this is a really important thing to remember as we get through this episode. So what you need to remember and take away was that he was charged, but he was not convicted. So talking about his parents' estate, it was uncovered that his parents did not have an estate plan. No wills, no trust, nothing. So their estate went by the intestate laws, which are the laws that govern when someone passes away without a will. And those laws say their estate goes to their 3 children, Linda, Janet, and Alan. Alan, the latter, being the one that killed them. So after their parents passed, Linda and Janet were appointed by the court as the estate's executors. Once the initial paperwork shuffle was done, Linda and Janet, as the executors, asked the court to terminate Alan's right to inherit any portion of their parents' estate. Therefore, they were saying that he should not receive his share, given what he did. They made this argument based on Indiana's version of the Slayer rule. The court heard their argument and sided with them, meaning that the court said, nope, Alan doesn't get anything given what he did. Well, Alan appealed their decision to try and get a different outcome. Would you believe me if I told you that the Court of Appeals did come to a different conclusion and said that Alan should be entitled to his share of his parents' estate? Well, believe it, because that's exactly what happened. Why? Well, they hung their hat on that our state's Slayer rule requires an actual conviction. And here, Alan was not convicted. He was charged, but ultimately found not guilty by reason of insanity. So they basically said that because of his lack of conviction, the Slayer rule is not even applicable. The court, in coming to this decision, analyzed several other states' decisions with similar facts. Like in New Jersey, at least according to this 1983 decision, and I'm not sure if New Jersey has changed their statute since then, New Jersey's Slayer rule requires a showing that the killing was intentional. Though in a New Jersey case that interpreted this statute, they found that someone who was found not guilty of murder by reason of insanity could not be said to have done the act intentionally, meaning the killer could keep their share in their victim's estate. The court even referenced a very similar case in New York, where a wife killed her husband. She was found not guilty of murder by reason of insanity because of that. So because of that, she did not know the nature and quality of her action. So she was able to keep what she received from her husband's estate. And Minnesota, Florida, Texas, and California all have similar cases like New Jersey and New York, which allow the killer to take under the victim's estate by reason if they are found not guilty, or perhaps guilty, but by, they're not convicted because of reason of insanity. So it seems that Indiana followed the trend of these states. At the end of the Court of Appeals opinion, it shares, quote, "The result we reach, while firmly grounded in legal precedent, may prove unpalatable to some. However, it is not our office to find the law one way and hold to the contrary. If law as it now exists is in need of change, that task is for this legislature." End quote. I don't disagree. If the letter of the law says X, then the court's responsibility is to take the facts of a case and analyze that against X. It's not the court's responsibility to change X to Y. That is our legislators' responsibility. On a somewhat random side note, but related, I've been doing this estate and elder law stuff for over 10 years now, and I've seen a lot. I've worked on a lot, I've heard a lot, and not to say I've seen everything, because I know better than to say that. But I actually have worked on an estate case involving a murder. Crazy, right? Well, it involved someone, let's call her Sheila. Sheila killed her family member Barbara, and then after killing Barbara, Sheila committed suicide. Long story short, in that case, Sheila's siblings asked the court to not send Sheila's share of Barbara's estate to Sheila's estate since Sheila killed Barbara, and they succeeded. Sheila's estate did not get any part of Barbara's estate. So why is this case different than the case earlier I talked about? Well, since Sheila committed suicide, Sheila was not charged and obviously not convicted. So back to Alan's case. Alan's sisters, Linda and Janet, actually argued against Alan's position, and Alan's position being that because he was not convicted by reason of insanity, that he could receive his share from his parents' estate. Linda and Janet actually cited a case that was very similar to the case I actually just shared, and it was not that case, not the case that I worked on, but super similar facts. So in the case that they cited, that case, a husband killed his wife, and then the husband committed suicide. In doing so, he avoided prosecution, right? And like the case I actually worked on, he was not charged nor convicted. The Supreme Court in this case about the husband and wife ultimately said that the husband's estate should not receive any benefit from his wife's estate, regardless of a conviction or not. And here, there was not, of course. In their opinion, they anchored to interpreting the Slayer rule, but sort of adding in like a sprinkle or a dose of equity into the statute. So, if I interpret all of this, the biggest difference to me is that if the killer survives and if the killer is charged but is not convicted due to a reason of insanity, meaning he or she just didn't understand the quality and nature of his or her act, the killer may be able to take under the victim's estate. But say the killer is convicted, or maybe is not convicted, but due to a reason like the killer committed suicide, the killer cannot take under the victim's estate. And perfect time for a reminder. Every court can interpret things differently, and every state can make different rules. And my little lawyer world is constantly ever-changing. So if we go all the way back to the beginning and talking about old Taylor Swift's anti-hero song lyrics, I have this dream, my daughter-in-law kills me for the money, she thinks I left them in the will. What do you think now about these lyrics? I'll tell you what I think. My brain first goes to, okay, it's the daughter-in-law, meaning it's the in-law and not the actual child. So if it's the daughter-in-law, would the victim's child not be able to inherit given everything we just learned? If the child's not the one that actually did the murder, would that be a case of like first impression if something like that happened? And heck, there's probably a case out there somewhere where the in-law killed. So that would be kind of the first level to analyze. Like if the in-law murders, can the child, the spouse, the child of the victim still inherit? Now, the relationship between the killer and victim, and would the actual child be punished for what the child's spouse did, that's that first level to analyze, right? And the second level would be kind of this conviction prong. Is the in-law convicted? If yes, the Slayer rule would likely apply and say the killer cannot inherit. But if not, why was the in-law not convicted? Was it by reason of insanity? Or because they'd committed suicide? And we talked about both situations here. So it's a lot to think about, right? And analyze for sure. So I guess we have Taylor Swift, T Swift, to thank for the contribution on bringing this topic up for us here at Legal Tea to dive into. Okay, let's wrap this episode up. Next week's topic is on estate planning of the rich and famous. And on that episode, we're going to be diving into what has happened estate-wise following the too soon and sad passing of famous musician Aaron Carter. If you don't recognize the name, Aaron Carter is the brother of Nick Carter, one of the members of the Backstreet Boys. Aaron never got quite as big as his brother, and definitely not the Backstreet Boys, but he did have a few songs that made it really big. So tune in next Tuesday, Legal Tea listeners, to hear all about it. Talk to you then, and stay well.